Good morning. I'm Joan McGrath. We're all aware that medical costs, even for the shortest hospital stay, have gotten out of hand. No doubt one reason prices have risen so dramatically is the increasing cost of medical malpractice insurance. And as we know, whenever insurance costs go up, the increases get passed along to us, the consumer. Well, recently, the Illinois State Medical Society proposed a series of bills in Springfield that would limit doctors' liability in medical malpractice cases. So, malpractice insurance would level off, and that would be good for the patient. Or would it? According to some lawyers, the proposal would seriously limit the amount of damages that you or I could get if we ever had reason to sue a physician for malpractice. It is a complex issue, to be sure, but it's so vital that we'll attempt to sort it out today on Dimensions. In Springfield over the issue of medical malpractice, and it's all a matter of money. On one side are doctors, who are being sued more and thus paying more in medical malpractice insurance. On the other side are attorneys, who make their living getting for their clients malpractice settlements that are as big as possible. But where does the patient stand in all this? These are my guests today. This is Dr. Robert Hamilton, attending Chief of Orthopedic Surgery at St. Joseph's Hospital and President of the Illinois State Medical Society. And this is Robert Clifford. He's an attorney with the law firm of Clifford and Henley and chairman of the Illinois Trial Lawyers Association's Committee on Medical Malpractice Legislation. Gentlemen, 1 out of every 5 doctors in this country will be sued at least once this year. Does that mean that there's a lot of bad medicine going around, or does it mean that we as patients are not willing to accept the inherent risks that we face when we go in for any medical procedure? Dr. Hamilton, let's start with you.
Well, Joan, it's even worse ratio here in the state of Illinois. 42% of Illinois physicians can expect to be named in a malpractice suit this year.
That is staggering.
It's really staggering. There's always been cases where mistakes have been made in medicine. There has been malpractice for as long as there's been doctors. I think that we live in a very litigious society now. People, with the advance in technology in medicine that we hear about every day, I think people feel that if they don't get 100% result, no matter whether they're briefed about that before a medical or surgical procedure, that if they're not 100%, then somebody made a mistake, and if somebody made a mistake, they should pay, and it's through malpractice litigation that they feel that they should be paid.
When we say malpractice, of course, what immediately comes to the mind of the consumer is the physician, and the cases certainly have been documented, who do surgery and leave a surgical sponge, it emerges later upon x-ray, or a surgical instrument inside the patient. I mean, these are outrageous acts of malpractice. How prevalent are they?
Not really very prevalent. What you talk about is strictly negligence, where mistakes are made which should not have been made. When a patient has been injured by this type of thing, then we feel that the patient should be reasonably and fairly compensated for the loss of time, loss of earnings that the mistake caused in them.
And pain and suffering.
To a certain extent, yes.
How do you react to this discussion, Mr. Clifford? How do you respond to the question of severe impaired physicians, medical malpractice where a surgical instrument is left inside a patient on one hand, and frivolous lawsuits that don't understand that sometimes minor mistakes happen?
Well, I think before you criticize the system, the way it exists, you have to take a look at how it really works for physicians. As it stands now in Illinois and elsewhere in this country, physicians are very much a privileged class in the manner and method in which lawsuits are filed. You cited a moment ago the statistics about how often physicians can expect to be sued, and Dr. Hamilton responded with an even higher percentage in Illinois. Yet we know from studies by either the Rand Institute or AM Best Company, which is an insurance-affiliated organization, that as few as 1 out of 10 actionable cases are actually filed in the courthouses in this country. It's one thing, of course, for an individual to be subjected to treatment that is a deviation from the standard of care, and that person then have damages coming to him. It's another thing, clearly the physicians argue that we have these frivolous lawsuits, and it's a question of how you define frivolous. You know, you have to accept that in America, people have the right to file a lawsuit in a courthouse. But before they can win that lawsuit against a physician, there must be a physician that will come in and testify that a given physician was careless in the way that he handled the case. That is a benefit that the physicians already have, and it's not applicable to any other area of law when it relates to injury cases. If I were to be involved in an automobile accident today with you, you could get up on the witness stand and tell your side of the event, I could tell mine, and a jury decides.
But of course I don't have any specialized expertise as a driver, whereas a physician has a very highly specialized expertise in the medical field.
And that's why we have the law requiring expert witnesses. Now, one of the problems that the doctors claim to face is the numerosity of frivolous lawsuits that are filed against them. And indeed, many studies have demonstrated that that allegation is correct. And the Illinois Trial Lawyers Association has promoted specific recommendations that would require lawyers to attach a certificate of merit to their complaint, saying, in essence, that they have had the facts of the treatment reviewed by a consulting physician, and that based upon that review and their own analysis, there is reason in which to file the case. And we recommend that that's something that should be done.
I gotta say, gentlemen, here I sit as a consumer, and I don't understand all the complex issues involved. I do understand, though, that when your insurance rates go up, when you file a lot of suits and force him into court to defend himself, right or wrong, that your insurance rates go up, and I wind up footing the bill. I think that is the point at which the consumer becomes outraged. What do you say to a fellow who, perhaps because of this bad economy, has lost his job? Perhaps he doesn't even have insurance. The rates of medical costs have soared so considerably, he can't even afford access to medical care.
But you're even assuming that those costs are attributable to the cost of malpractice insurance, and that's a major leap. In other words, if the statistics now show that in America in 1983, physicians paid no more than 3.5% of their gross overhead to the payment of malpractice premiums. And that's followed closely by about 3% for the cost of maintaining their cars. This is indeed a consumer issue. And let's put it in perspective real quick. What the Medical Society is asking for is special legislation that would limit the amount of recoverable damages that an individual could get in this country, in this state in particular. And to use two examples that have been in the media lately, you have in Albany, New York, the young lady who was pregnant that was paralyzed from her neck down while pregnant in the hospital because of admitted malpractice. In that case, if that were to occur in Illinois and the Illinois Medical Society's package were to control, the patient would receive a maximum of $100,000 for that injury. All of the patient's pending insurance coverage would go to the benefit of deferring the cost that the physicians would incur in providing future medical care for her. And then when the insurance runs out, she either becomes a ward of the estate or she dies. To use another example, in Florida, there was the very well-known photographer who was in surgery to have an eye extracted, and they put in formaldehyde into his system, and he died. And he
originally intended to preserve the eye that was removed.
Precisely. Under that case there, he died with a wife of 34 years. his wife, under their package, would receive a presumption of $25,000 in damages, but no more than $100,000 in damages. And I ask you, is that fair? Or apply their package to a case that happens today. If a child is brain damaged in an automobile accident, under the current law, in the automobile case, all of the insurance coverage necessary, provided it's there, and all of the damages necessary to allow this child to lead a life without expiring prematurely would be available. If that same thing occurred in a malpractice case under their package, that child's insurance coverage would eventually expire to the benefit of the defendants. There would be a cap on the amount of damages in the area of $100,000. And then guess what? When all that money runs out, whose problem is it going to be? It's going to be the consumer, because your taxes are going to go up, because that person's going to become a ward of the estate. And when the state cannot pay the costs necessary to supply health care to that child will die. That's a societal question that is on the table today in this state because of this package.
All right, Dr. Hamilton has been shaking his head.
Well, Mr. Clifford hasn't told all the story. In the first place, in the state of Illinois, the average malpractice premium, that is the family practitioner who does no surgery to this highly specialized neurosurgeon, high-risk surgery, the average malpractice premium is between $8,000 and $10,000, which ranges anywhere from about $2,000 up to $36,000 to $42,000 a year. So this is a little bit more, I think, than the average physician spends on his vehicle. The second is that there are these gross cases of negligence that we see. There is nothing in our legislation which would either limit anyone his or her day in court, nor would limit fair recompense to somebody who has been injured. For example, he said a $100,000 limit. That is only a limit on the non-economic damages, on the pain and suffering. There would be absolutely no limit to economic losses, custodial care that somebody might need for the rest of their life. So there is no cutoff, and under a properly structured settlement, the patient would never become a ward of the state.
Do you know what a structured settlement is, Joan? Here's what a structured settlement is. What the insurance industry is promoting today, and the medical society is indeed the insurance industry, they want to take money and go out and buy an annuity. And that's what a structured settlement is. They take $100,000 or whatever sum of money and go to an insurance company and provide a stream of income. So what they want to do is they want to compensate you based upon what they perceive to be fair and just compensation, not what a jury does, not what you might think, so what they think is appropriate. Then they want to keep the money, they want to give it to another insurance company and pay you off in pieces, so that if a jury says that you're entitled to $800,000 in present dollars on the table today, they want to say, let us take $150,000 or $200,000 and go out and pay an insurance company to pay that off in the passage of time.
I suspect some consumers would say if you can demonstrably prove that that will keep costs down for the general society, there's a point to that.
It's a cost containment measure,
whose costs
and
are being kept down.
it also ensures that a patient is going to have care for the term of that contract, whether it be a few years or it be for lifetime.
You know, we are talking about cases that are dramatic, and there's no question that it was an enormously dramatic case in Florida. The man who lost an eye and his life at the same time, the latter unnecessarily. Let's get more down to earth, more back to the level at which I can identify with this situation. It is alleged that a lot of suits are brought unnecessarily. Mentioned before, frivolous suits. It is a fact, is it not, that 70% of suits that are brought in malpractice court in the state of Illinois are either settled out of court or awarded in the doctor's favor?
No, that number isn't correct. Here is what is correct. The doctors claim that they close 80% of their files without ever paying any money on them.
That's true.
That means, then, that if I were to file a lawsuit today against 4 physicians, and a jury says I'm entitled to a verdict against 2 of them, or they settle as to 2 of them, and they dismiss the other 2 cases, then that means that they had 2 valid cases and 2 that they deem frivolous. And that's a statistic that we don't think ought to be used. The other
That's
statistic...
true, but you see, you should never have filed those other 2 cases in the first place.
Well, that's your opinion about it. It may not be, and this is the problem, Joan, that there are devices that exist in the legal system today that could be utilized by the physicians to get out and get dismissed from cases, and they don't vigorously pursue them. We don't for a minute deny that lawyers do indeed file lawsuits when they should not file them. But there is not one portion of their package that is pending in Springfield that would address itself to requiring lawyers to sharpen up the filing of their cases. And additionally, there is not, if you take a look at what is involved in that package, there is not one thing in that package directed to improving the quality of health care. All we hear about are the big verdicts and the settlements and the frivolous lawsuits. I ask you, what is the medical community doing to improve its lot? And the answer is they're not doing an awful lot at all.
It's a darn
answer.
good question, Dr. Hamilton.
I'd like to answer that, Joan. The Illinois physicians practice under the Illinois Medical Practice Act, which the Medical Society backed when it went into law in the 70s. This is one of the toughest medical practice acts in the country, and as a matter of fact has been used as a model for other medical practice acts in other states. This established a medical disciplinary board as a part of the state organization, which has to investigate and discipline by taking away licenses, even bringing charges in court against physicians. Because the investigations weren't funded, we voluntarily increased our licensure fees so that this money could be made available for investigation by the disciplinary board. 2 years ago, we were behind the mandatory reporting amendment to the Medical Practice Act, which means that any adverse malpractice settlement, any disciplinary action by a medical society or by a hospital, or in fact any complaint by a citizen, has to be reported to the Medical Disciplinary Board for investigation. I think we've got a pretty clean house.
How many licenses have been revoked and how many people have been suspended, Doctor?
I think there are actions about 6 every month from the Medical Disciplinary Board.
And when you say, what do you mean by that, actions every month?
License suspensions, revocations of license, probation.
Well, I asked you, at the last time, Joan, that we were on a program, I spoke about a thing called Project Justice, and Dr. Hamilton asked me to supply him with some information about it, and I did in the timely fashion that I said I would. I would challenge him to supply to us any information that shows that there are 6 a month, and I respectfully suggest and would guess that that is not going to occur.
Nonetheless, we are
it's
talking
a matter
about
of public record.
We are talking about apples and oranges, are we not?
Sure we are. It's a diffused issue.
The outcome of a medical malpractice litigation means nothing in terms of disciplining the physician. It means essentially his rates might go up. Am I right?
Well,
it doesn't eradicate bad doctors from the system.
Under the Mandatory Reporting Act, any adverse decision or settlement against a physician is reported to the state, and the state has the power to license and regulate the practice of physicians.
And when was the last time they've taken someone's license away?
I don't know, I suppose last month.
Well, you're the president of the medical society. Don't you think that's something you ought to know, or that your society ought to know? I respectfully suggest that it is.
Let me ask you a question out of left field, perhaps, but it's one that interests me, and I think, Dr. Hamilton, you can best explain it. What happens to a physician who's sued for malpractice? Let's say he doesn't deserve it. Is there a deleterious effect on the quality of care that he gives subsequent to that litigation just because he's so stressed, because it compromises his concentration, because he's really upset about the whole situation? Is he less of a physician thereafter?
Any type of court problem is going to give any citizen stress. When a physician, I don't think there is any physician who really tries to harm a patient. He may make mistakes, there may be complications that occur, but most physicians are pretty devastated when they get that subpoena that they're being sued for malpractice. Certainly, the insurance that they pay for, and they pay plenty for, as I said, is going to take care of the defense. But this means a great deal of lost time And physicians who have been sued more than once are afraid. And people that know that 4 out of 10 chances they're going to be named in a suit in a year are going to be practicing defensive medicine.
So there's another cost factor here. They're going to be assigning more tests, longer hospital stays.
Yes, and when a physician looks in his waiting room and feels that maybe 1 out of 2 of those people is going to sue him, what happens to the old patient-doctor relationship that used to be characterized by mutual trust?
Oh, come on. I wouldn't sue Dr. Welby. I have no relationship with the specialist. My mother-in-law had open-heart surgery. She saw her surgeon once before the operation, once afterwards. I mean, there's no relationship there. I think that you've made us, in some sense, rather cold to physicians. We'll sue you because we don't know you. You don't represent anything more to us than a medical practitioner.
Well, I think people are expecting higher technical care. They are going to specialists more and more. I think some people do get to know their specialists, some people don't. This is unfortunate. But again, the defensive medicine is really a cost.
Can I respond to that?
Naturally.
Yes, thank you. In spite of the strength in which both Dr. Hamilton and I might present our positions, the fact of the matter is that there is a problem that exists in this state with respect to the quality of the filings that the lawyers do indeed march over to that courthouse and place on file. And that is to say that I am convinced, as the chairman of the Illinois Trial Lawyers Committee, and many of our members are convinced, that the lawyers could do more and do a better job to improve the review that is necessary before a lawsuit should be filed. And we have promoted and suggested various means of alleviating this problem with the Medical Society, and our efforts are continuing in that regard. Both Dr. Hamilton and I have very serious ongoing discussions about this matter.
Are we to perceive this as concessionary behavior?
Well, sure it is, because it's responsible behavior. The one thing you have to understand
there are
is
ambulance chasers in your business.
I would assume that's true, sure. I don't know what the word ambulance chasing to me is a phrase that historically has been associated with automobile accident cases. In the area of medical malpractice, Dr. Hamilton is absolutely correct that society today expects better results from the physicians. And so the first time that you get a bad result, the very first thing that people think about nowadays is let's go to a lawyer and see if there's any actionable negligence here that we should be talking about.
Let me then put a question to you directly, sure. Mr. Clifford. Contingency fees, it is said, the modus operandi of the way an attorney files litigation is in itself encouraging of such litigation. If you can make 50, 60, even 70%, or as little as 30% on a case, and you know that up front, certainly you're going to encourage suing, because the more suits you get, the more money you make.
Well, let's carry that all the way through. The contingency fee historically has been the key to the courthouse door for people who cannot afford to be paying lawyers like the ones that work for Dr. Hamilton $100 an hour or whatever they charge.
What's your fee?
My fees are a 1/3 contingent fee, which I think is a fair and reasonable fee. If you take a look at the National Association of Insurance Commissioners last study, they showed that the malpractice costs nationally for payments and fees paid by the physicians is slightly in excess of $1 billion, with the fees and costs that they paid representing some $300+ million. 1/3 of $900 million, which is what the patients got, is about $300,000. Pardon me, $300 million. So overall, in malpractice cases, on average, plaintiffs don't pay any more in fees than do the doctors to defend them. But let me go back to your earlier question.
Yeah, the numbers are irrelevant. The question is, doesn't that in itself...
No, it doesn't. Take a look at the statistics. If they're winning 80, give them their due and say that they're winning 80% of all of their cases, doesn't that mean that lawyers are losing 80% of them? And it does. And if they're handling them on a contingent fee, then that means that every lawyer who's handling a malpractice case is only being paid 20% of the time, yet you, the consumer, have legal services. I think it's absolutely unconscionable to have legal fees in the area of 60 or 70%, and I don't know of any that do have them. If you do, I'd like to know about it, because I'd do something about it. But I do think that a reasonable legal fee, if you take a look at the AMA task force reports, it's a red herring to say, let's attack legal fees and the contingent fee, because the AMA, its own report demonstrated that a reduction in fees for the lawyers has no relationship with a lowering of the severity of the awards or the incidence of filing of malpractice cases. So the fee issue, so long as they're reasonable and lawyers don't charge 50%, which they should not, what's wrong with reasonable fees, especially if it's supplying you with a service that you would otherwise not be able to afford?
Dr. Hamilton, will you address that? Because one of the proposed bills in Springfield is to limit or eliminate contingency fees.
Well, first, I'd like to ask Mr. Clifford if he thinks we ought to get cut-rate lawyers to defend ourselves. $100 an hour is a going rate for any lawyer here in the city of
I think you have
Chicago.
terrific lawyers. I think you ought to pay them what they feel they're worth and what you feel that they should be paid.
Right. So
No one's attacking the amount of their fees.
Well, the way you said it, I thought you felt that we got very high-priced
No, what
lawyers.
I did say is that your fees and our fees, if you take a look at the total expenditure on malpractice awards and settlements in America, balance out to be about even.
I think you both earn too much money. Get to the question. We only have 2 minutes left.
All right. Actually, what we'd like to do is to make sure that the patient gets the greater share of the settlement or of the judgment in court. And it seems reasonable that the 1/3 might be lessened to a quarter, a tenth when you're talking in terms of millions.
There's a package in Springfield of 11 proposals that would totally overhaul the system of malpractice litigation in this state. Give me a prognosis. It's coming up for a vote when? What might happen?
My opinion is that there probably will be some reform legislation. I do not believe that the Medical Society's package will be passed, only because I think on the merits of it, any fair review of it says that it goes to the extreme. Leadership in both the House and Senate in Illinois are asking the Medical Society and the lawyer groups to try to sit down to come up with an amicable compromise, and we are making those efforts, as Dr. Hamilton is well aware, and that's what I think will happen.
If there's a compromise, Dr. Hamilton, if he's satisfied and you're satisfied, will I as a patient also be satisfied? Will I be best served?
Yes, I think so. One thing I'd like to say is Governor Thompson was concerned enough that he named a Blue Ribbon Task Force, which is studying the medical malpractice program, and we anticipate results from this task force the end of this month, probably before any legislation is results. I think from the recommendations of the task force, from our dialogue with the trial attorneys and the bar, I think that we are going to come up with some type of compromise legislation. Maybe nothing that, everything that we would want, but I think that it will protect injured patients' interests as well as trying to contain the cost of medical care.
Obviously, from my point of view, I hope that it provides and ensures higher quality medicine and representation that is rich with integrity, because I think that's what we as consumers and as patients not only want but also deserve. I wish we had more time, gentlemen. It's a frustration not to be able to explore this one in more depth because it is such a complex issue. If you want to get involved, there are two organizations. One is that Dr. Robert Hamilton represents is the Illinois State Medical Society. He's the president of that organization. Robert Clifford, my other guest, represents the Illinois Trial Lawyers Association. He's the head of their committee on medical malpractice legislation. I'm Joan McGrath. Thank you for joining us this morning. I'll see you again next Wednesday. Bye-bye.